move on to the Chappuis case. Case number, I'm not on the record yet. We're moving on to case number 19 CR 0069B. Patricia Chappuis, again being represented by Thomas Gibson, Esquire, and the state is being represented by John Friel. Mr. Gibson, do you want to put on record what's going on so far?
Yes, Judge. Pursuant to our negotiations, according to the memorandum of plea, Ms. Chappuis is, and I have the authority to enter this plea on her behalf. She's pleading no contest to disturbing the peace on count 1 and count 2, disturbing the peace as well, both misdemeanors. The reason they're pleading no contest, in particular because of the potential lawsuits that are hanging out there regarding the Northwest students and their parents. So we have to plead no contest. The other issue was, for those who are interested, this is a long tortured history. Back a couple of years ago, there was a Northwest employee who wanted to become a Nye County Sheriff's deputy. She was giving information to Detective Harry Means with the Sheriff's Office. She wasn't aware at the time that Northwest was actually working with the State Attorney General's office to comply with the law regarding drinking water. And because there's an issue out in Amargosa with a lot of the well water that has contaminants in it from mining, in particular arsenic and other toxic substances. Anyway, so that water issue was being worked through by the Chappuis and the state of Nevada. And then, of course, the Sheriff's Office was not privy to that. They thought they were going to jump in and save the day and create some big, huge criminal case, which is reminiscent to in a way, because when the present DA first came into his office, he got 2 brand new cases, the Northwest Academy case and then the Valley Electric case, one worse than the other. And so in both cases, it's the Sheriff's Office that dropped the ball, not the DA's office for not prosecuting them according to what the Sheriff's deputies or the Sheriff's recommendations were for the potential charges. We also have an additional issue is the NCSO failed to, they tested the students to see if they had any contaminants in their bodies, and they had a 50-50 chance of administering the right test. They failed. They gave the wrong test. The tests weren't can't be used to prove any criminal case against the Chappuis. So that's why both cases against Mr. Chappuis ended up in simple misdemeanors. There are other things out there that could have caused us problems and without any admissions on anything. But they were misdemeanor territory, and so that's why we decided that in the interest of justice, just to get this buried, my client is pleading no contest to the charge of disturbing the peace count 1 and disturbing the peace count 2.
And for the record, previously I had waived their appearance at this hearing. Okay, Mr. Friel, just to let you know.
Understood.
Patricia Chappuis. So, and was there any negotiations on any kind of penalty?
It was just credit for time served, because she actually went to jail for a while and had to bail out, which was another disaster in itself with the former bail company.
Okay. Is that correct, Mr. Friel?
That is, Your Honor. I think we put that on the record in April.
Okay, all right. Then I'll accept the negotiations of count 1, disturbing the peace. I'll accept the no contest plea, and then as wise as count 2, I'll accept the plea for disturbing the peace, no contest. On count 1, I'm going to order that she served 10 days in the county jail. I'm going to give her credit for 10 days already served. On count 2, I'm going to 10 days in the county jail, give her credit for time already served. Her case is closed.
Thank you, Judge.
Thank you.
See you, Judge.